Hello everybody, welcome to my channel. Today we're going to see about types of companies. Usually in law officers examination, a simple question that could be asked is how many directors are required for a private company? What is a private company? Or how many directors are required for a public companies, which is 3. What is the difference between public and private company? And whether the transferability of shares is restricted in private company or public company or not. What is a government company? What is a holding company? What is a subsidiary company? What is an associate company? And what is a one person company? These are ripe areas for exploit for it to be exploited by the examiners. So we have to see the basics of Companies Act, the types of companies where there is a high probability of multiple choice questions can be asked. So we are going to see this specific topic for you to help and clear the bank law officer examination. So what you will learn in this video, so we'll see the classification by liability. So like I said, a company does not have an unlimited liability, it has a limited liability concept. So the liability depends on the unpaid shares or guarantee. Then what is the difference between public and private company? And what is a OPC, one person company, and what is a small company? This key definition is very important. What is a Section 8 company and a corporate group, and what are the other types like government, foreign, dormant, and producer companies? Now, straight away we'll go into the classification by liability. The first, the most often, this is the widespread companies that is available, that is company limited by shares. Here the members liability is limited to the extent of the unpaid shares on them. For instance, if the share price is 10 rupees, the members have paid 8 rupees. When the company is liquidated, the liability of the members would be only the remaining 2 rupees. So that is what is the concept of uh, limited by shares. So in this concept, the liability is limited by shares, and this is the often the most used form of company under Companies Act. Now, companies limited by guarantee, this is kind of companies that can be set up in terms of members of association, clubs, etc., where each member undertakes to pay a certain money. So, based on they might have an agreement or contract, and based on that, based on the guarantee amount, say for instance, each member would say, I would pay 10,000. So that would be their liability. So this is company limited by guarantee. And then the unlimited company, these are very rare. Here the company's liability is unlimited, and this is very rare because once if it is an unlimited liability, the virtual distinction between a sole proprietorship and unlimited and the company's limited liability concept itself is erased. So this is a very rare thing, so it is not there, but I think you have to understand the concept. For a theoretical purpose, I have kept it. Next, let's move on to the private versus public company. The most important thing we have to understand is private company restricts the transfer of shares, whereas the public company, the transfer of shares is not unrestricted. It's not restricted. And most importantly, it should have a minimum of 2 members, and in public, the members must be minimum of 7. So members are different and directors are different. So for a public company, a minimum of 2 directors is essential, and for a for a private company, it is minimum of 2 directors, and for a public company, it's minimum of 3 directors. And there is a maximum member limit in private company, no such thing in public company. And the public company can actually invite the members to subscribe in their debentures. Debentures are nothing but a kind of a bond where the company raises capital and shares. So the company should have private limited in their name, and a subsidiary of public company is deemed to be public company. Similarly, a public limited company, a public company where the subsidiary, if a public company is subsidiary, they have a subsidiary, then that is deemed to be a public company. So these are the most important concepts in private versus public company. So the questions that can be asked is the director requirements, the membership requirements. In private company, membership is 2 to 200. In public, it is 7. to unlimited, and directors it's 2 for private, and it's 3 for public. And the most important thing is restriction on transferability of shares by the private company, whereas the shares are freely transferable in the public company. Now, one person company, this is a special company where only one person can form a company, although there is a requirement of a nominee. So the person must nominate a nominee who will take care in case of an adverse event like a death or incapacity, and it must have a minimum of one director, and the member and the director can be the same person. And as opposed to a small company is company where the paid out share capital is less than 10 crore and the uh, turnover is less than 100 crore, and both the conditions should be satisfied. Say for instance, if a paid out share capital is less than say if it is 5 crore, and if it is turnover is more than 100 crore, then it would not be a small company. So both the conditions must be met, and it exclude holding subsidiary companies, Section 8 companies, and special act companies. All these things are excluded. A small company must have a very narrow definition which fit into the uh, threshold given in the Companies Act, that is less than 10 crore for paid up share capital and less than 100 crore for a company's turnover. And Section 8 and the corporate group. Section 8 is a type of a charitable company. It is used to promote commerce, art, science, charity, and it applies its profits to its objectives and pays no dividend to its members. So it cannot pay any dividends. All its profits has to be reapplied to the objective, that is the objective of developing science or commerce or charity, arts. Now, arts will also include sports. Now it enjoys relaxations, and license may be revoked for breaches. That is very important concept. Now, coming to the holding subsidiary and associate company. So the holding company is something which controls either the board of directors of the subsidiary company or 50% of the subsidiary company. More than 50% of the subsidiary companies holds more than 50% of subsidiary companies capital, and subsidiary is a controlled company, and associate company has significant include that means a company which has almost 20% of the voting power. So that is that is called an associate company. So if it is more than 50%, that would be a holding company, and if it is more than 20% but less than 50, then that would be a associate company. Other types of company, the most often we'll come across this government company. The examples include public sector banks like SBI, UCO, Canara, where almost 51% of the paid up share capital should be held by the 51% of the paid up. So the other types of companies, including foreign companies that is incorporated outside India but has a place of business in India. Good examples can be a lot of companies, that is like Teslas and other companies which are incorporated outside India, has a place of business in India, even Flipkart, which was incorporated in Singapore. Then a listed company, which is where it is listed in the stock market, stock exchange like NSE, BSE. A dormant company is an inactive company which is formed for future purposes. This is very similar to a shelf company concept in United Kingdom, because the company is already set up or anything. You do not go over while setting up a new company. Anybody who has a dormant company, the person who needs to start a company can go and buy the company and quickly start a business. Producer companies are primarily for farmers. So that is one type of company which is in the Companies Act. So a quick recap, like I said, companies, the fundamentals of Companies Act is based on limited liability. It should be either limited by shares, guarantee, or unlimited liability. And private company has 2 to 200 members, while public company has 7 to unlimited. The directors are 2 for private and 3 for public, and one-person company can be based on one person, and there must be nominee in case of an adverse event of death or incapacity. Small company, the criteria is less than 10 crore capital, paid up share capital, and less than 10 crore in turnover. and charitable company cannot pay any dividends. It's a Section 8 company, and government company is at least 51% is held by the government. So the maximum number of members in a private company is 200. With this, we conclude on one of the most important topics in Companies Act, that is types of companies. So if you like this video, do share it with the people for whom it will be helpful. If you have any doubts, type in the comment box. I would be glad to help. The materials and course descriptions will be in the video description and other links. Do read the description and pinned comments. Uh, Thank you.